Thank you, Mr. Chairman. We've done a lot of this today, and there's a lot going back and forth, but let's remember what this hearing is about today. This hearing about today is about holding the Attorney General in contempt for violating a subpoena that he would have had to violate the law to comply with. We can talk about speeches, we can talk about interference, we can talk about, we didn't really mean that he had to provide grand jury testimony, but we've spent the last hour and a half looking through any comments that have been made on news or in print or anything since this entire thing came up. And you know what's interesting? Not a single person has said we don't really want grand jury testimony. It is the full unredacted Mueller report. That's what the subpoena says. That's what the narrative is. So to have this reasonable dialogue after we've already committed to a contempt proceeding seems to be a little, if we're using phrases, I'll just use cart before the horse, different types of issues. What we did find, though, was the chairman on CNN stating that every other AG has gone to court. And outside of, I think, the ranking member making sure that's a misleading statement, it's a political argument and not an adequate reflection of the current status of the law. So let's make sure we at least understand what the current status of the law regarding release of grand jury testimony is. There is no federal code compelling the AG to go to court voluntarily to release grand jury testimony. The AG has the sole responsibility and prerogative to determine what DOJ's position will be on the release of grand jury testimony. There is no law that allows a congressional subpoena to compel the AG to go to federal court to release grand jury testimony. The chairman and the majority may want him to release that information. They may think they're entitled to that information, but they have by issuing a subpoena, you cannot force the Attorney General to release that or to go to court to release the information. And so we're offering the amendment, which is, and we have cited several different cases and have brought up for various different reasons. One of them is the Holderson case, Jaworski case. These are cases regarding impeachment with President Nixon. But one of the things we haven't done yet is talked about a case that was decided a week ago. And I think this is probably the most important thing that has been missed in this hearing is there seems to be a failure to recognize that there is no guarantee that the court would require the release of this information. And Wheeler v. Barr, which was just decided last month in the same D.C. circuit that we continue to cite from 1972, held that Rule 6E makes it quite clear that disclosures of matters occurring before the grand jury is the exception and not the rule, and sets forth in precise terms to whom, under what circumstances, or what conditions a grand jury information may be disclosed. Rule 6E restricts that persons bound by grand jury secrecy must not make any disclosures about grand jury matters unless these rules provide otherwise. The only rule to provide otherwise is Rule 6E3. So let's be clear about what we're doing. This isn't a fight between Congress and the executive branch. This is the fight between the Democratic leadership, the president, and their base. They know the American people don't want an impeachment proceeding. And if they want to continue down this rabbit hole and continue to have this type of showmanship, then let's at least be clear about what the status of the law is. And with that, I yield back.